My Lord Lieutenant, High Sheriff, Provost Chancellor, Dean and Canons, Mr. Justice Benethan, it is a profound honour to address you this evening as we mark the opening of Oxford's legal year. I shall begin by admitting that I was rather intimidated when I received the Vice-Chancellor's summons to preach a university sermon. Even the most cursory research suggests the high calibre of preachers who normally offer their reflections at the court service. From Baroness Hale, our first female president of the Supreme Court, to John Keble, who, at least according to John Henry Cardinal Newman, used the occasion to launch the Oxford movement. Alas, with a law don from Magdalen just down the high street, I fear you've drawn the short straw tonight. My research between law and computer science explores the rise of algorithmic management, when machines replace humans as managers and workers, from Uber drivers and Amazon warehouse workers to law firm partners and even, dare I say it, university professors, find themselves surveilled, quantified, and controlled by AI. More fundamentally, what I care about is the demise of human agency and what the law can do to protect, foster, and restore it. And that is what I want to talk to you about tonight. I want to talk about the importance of judgment, more specifically, human judgment, and its enduring, if not increasing, significance in the age of AI. Some of my lords and ladies will have attended a service at Westminster Abbey last week, where the Bishop of Kensington addressed senior leaders of government, the bar, and the judiciary. In her sermon, she prayed for wisdom as the crucial add-on to what we cherish most in this university, knowledge. She reminded us of the old adage that knowledge is knowing when a tomato is a fruit. Wisdom is knowing not to put it in a fruit salad. I completely agree. And yet, I think that what we need even more in a time of rapid technological acceleration, which touches all sectors of society, not least the law, is even more. In addition to knowledge and wisdom, we need human judgment. Now, in the midst of summer, when most of us were hopefully up to more pleasant things, Lord Timpson, the Ministry of Justice's lead minister for AI, slipped out his AI action plan for justice, promising, amongst other things, I quote, to embed AI across the justice system. I knew I shouldn't have checked my emails. Oh dear. Now, don't get me wrong. I'm not standing here as a Luddite, advocating that we smash the machines, return to the Dark Ages, have written files and the literal red tape, that's where the term comes from, holding together the bundles being brought to court. Not at all. But I do want to stand here as an advocate for wisdom and judgment in how we think about AI in the law. AI in the law is something that we simply cannot do without human judgment. to be perfectly honest with you, there's some very senior and influential figures who would disagree with what I'm saying. A popular advisor to the judiciary is fond of equating digitalization in the justice system with, I kid you not, selling DIY equipment. It's not about the technicalities of the drill, he suggests. What people want is holes. In concrete terms, and here I quote, litigants do not really want courts, judges, lawyers, rule of procedures, and the rest. Well, with utmost respect to the non-lawyers in the room, this is a technical legal term, but given the presence of the dean in the sacred place, I had better not explain it to you in great detail. But with utmost respect, I think that is deeply misguided. Justice is not a service. Justice is not an outcome. It is empathetically not a hole in a wall. Again, let's be clear. The technologies bundled together under the AI label can be incredible. And yet, more than ever, we need to become extremely discerning in when to deploy them and when not. Computer scientists have called for the involvement in automated decision-makings of humans for a very long time. One of my research assistants dug up a paper by naval engineers in the 1940s who emphasized the need for, I quote, human operators in the control loop, seen as crucial to ensuring accuracy in some newfangled digital bombing and navigational systems. We've moved on a bit from then, but the legal equivalent today is a right to a human decision. Or, in the presence of such senior distinguished judiciary, let's be technically accurate, a ban on any, I quote, decision based solely on automated processing, which produces legal effects concerning the data subject, or similarly affects him or her. This right to human decision, enshrined today in Article 22 of the General Data Protection Regulation, the GDPR, has a surprisingly long historical pedigree. France went first. The Loi Informatique et Liberté prohibited judicial decisions taken on the basis of automating profiling as long ago as 1978. By 1983, the Bundesverfassungsgericht, the German Constitutional Court, had recognized that fully automated data processing was an interference with the constitutional right to informational self-determination protected by Articles 1 and 2 of the Grundgesetz, the very core of human dignity and personal freedoms recognized by the Constitution. And yet, despite this considerable legacy of the right to human decision, it hasn't been as straightforward. It continues to be contested as a human right. Commentators have recognized the many trade-offs involved. Think, for example, about the trade-off between efficiency gains and automation risks along a spectrum of human involvement, as Lord Sales of the Supreme Court put it in a recent lectures. More fundamentally, concerns have also been raised about the fate of that human in the loop. Imagine you are the decision maker faced with a human decision and you get to choose whether to follow the machine or make your own call. Perhaps, as Elish memory put it, the human ends up being nothing more than the moral crumple zone, You know the thing in your car that crashes when you hit something? Well, perhaps the human ends up in exactly the same position, taking the blame for errors when things inevitably go wrong, and thus shielding, protecting the automated systems, its developers and deployers. I reckon I've already pushed my luck by invoking the GDPR in a sermon. For anyone who will still bear with me for just a tiny bit more law, here's the twist. As of early next year, we will no longer enjoy the right to human decision in English law. Bar for a limited exception covering special category data, Section 80 of the rather catchily titled Data (Use and Access) Act 2025 will allow fully automated decision-making even where it involves the use of your personal data. Is this a bad thing? Should we be concerned? Well, as inevitably any lawyer would say, it depends. There are lots of sectors where automated decision-making isn't inherently problematic, especially if we have sufficient safeguards to frame and contest the result of those automated decisions. What, in my work, I've termed the need for humans not in the loop, but before, after, and above the loop. Human decisions, in other words, are not a universal answer to the challenges posed by AI. Instead, I suggest, our ultimate goal has to be the protection of human agency. But, and here we get to the very core of my sermon, there are some contexts, particularly contexts where the stakes are high, where nothing less than human judgment will do. And what higher stakes could there be than decisions concerning individuals' life and liberty? Though I am relieved from the white glove ceremony to learn that no human lives were at stake in judicial making in the last year. In today's first lesson, the High Sheriff read to us from the prophecy of Isaiah. It's a puzzling text, isn't it? It's jarring, even in its core message. In the rabbinical tradition, it has come to be understood as a key warning against empty rituals, against empty ritualistic justice, if you will. Precisely the sort of thing an AI judge would offer you. What Isaiah calls for instead is justice that is authentic, justice that is compassionate, justice that is focused on the dignity of all. Justice, in other words, which could not exist without human judgment. For a final time, let me just make it clear that my plea tonight for human judgment should not be taken as suggesting that human decision makers are infallible. We lawyers wouldn't be in business if they were. Indeed, I still remember my shock, surprise, bemusement when I first learned that economists see judges as the perfect random variable. Not so good when we teach about the rule of law. But, as Chief Justice John Roberts of the US Supreme Court warned in 2023, excessive automation risks, I quote, dehumanizing the law. And there we are then. There is so much more to the administration of justice than questions of expediency. Human judgment is crucial for legitimacy. Human judgment is crucial for dignity. Human judgment is crucial for mercy. Human judgment is crucial for legitimacy because a foundational AI model could never provide the guarantees of judicial independence essential to our constitutional settlement. Human judgment is crucial for dignity because the right to be heard and attempt to be understood lies at the very heart of procedural justice. And time after time, that human element has been shown to be just as important to litigants, if not more important to litigants, than the eventual outcome of their case. And perhaps most importantly, and there's one thing you take away from tonight, this is it. Human judgment is crucial for mercy. For mercy, because sometimes the strictures of the law do need to be tempered by compassion. Mercy, as St. Thomas Aquinas so properly put it, is the fullness of justice. As lawyers, we live by maxims, from equity to natural justice and so on. Rather curiously, running a team of both computer scientists and lawyers, I found that occasionally they tend to end up coining modern equivalents. So tonight, and I particularly want to acknowledge my senior postdoc, Dr. Sig Silverman, and his inspiration, Professor Elizabeth Gerber, I propose to conclude with what we might think of as the very first maxim of AI and the law. Sometimes, my lords and ladies, the best AI is no AI.